creates duties in public interest and imposes punishment for breach of that duty falls under the branch of criminal law broadly. However, the common law, which creates rights and obligations in a person or his things, please mark the words, in person or in his things, is classed as civil law. This is again, I must clarify, a conceptual analysis in that it has to be like this. There's nothing like a law over the law to classify the law as X, Y, Z. The parliament makes the law. The judiciary has developed the unwritten law where there is no positive law or where there is no law of the parliament. And over a period of last 700 years, beginning from 14th century in England, we have seen a vast body of law. We classify it as civil and criminal or public law in these days, but nothing as such a strict concept exists. It is quite possible that something could be both. Something called quasi-criminal law is there, quasi-civil wrong is there. So all these things happen. But as I said, to have the clarity of the subject, to understand, it is necessary to get into this, which might be of usefulness to the practitioners in law. Now, Mr. Vikas, can you share the PDF which I sent?
In the group or the chat box?
Well, I don't know how this, but anyway, if you can share it, fine.
Yeah. No, I'm sharing the on the WhatsApp chat, the YouTube channel link. I will share it after the
right. Then I just proceed.
Yes.
Okay. All right. Okay. That's fine. Okay. Now let us start with how the civil law develops. Firstly, in a broad sense, all rights in person or in his things are property rights in a broad sense. Okay. Even the rights of master over the servant or father over the children are considered to be property rights. This is in a broad sense, theoretical, but this is obsolete. This doesn't hold good anymore in the common law or the law as enforced in India. The conceptually, the property rights are classified into proprietary rights and personal rights. So proprietary rights and personal rights are the two sub-classification of property rights. The former relates to that is proprietary rights, the individual's rights in estate, that is the estate which he has a control, the thing. Then personal right concerns his status or personal condition, like right to marry, right to adopt. These are the personal rights, or right to have guardianship of the children, or the rights of the children or the father, or the rights of the spouse or the husband for maintenance. These are the personal rights. The proprietary rights is synonymous with property rights in common law. Okay. Then further, not all proprietary rights are property rights. The proprietary rights are classified into further proprietary rights in rem and proprietary rights in persona. Further, rights which are in rem and which relate to corporeal property, namely land and chattel, that is immovable, are strictly the property rights in law. So when the great body of civil law talks of property rights, it actually comes down to the proprietary rights in land and the movables. Beyond that, they are not proprietary rights. like intellectual property rights. The word property rights is used, fine. But in a strict sense of English law, or the common law, which we have adopted, they are not proprietary rights. In fact, recently the US Supreme Court or some court, I think US Supreme Court has taken a view that the intellectual property rights are public rights. They are not, in a sense, the private rights as understood. So this is how the law is. So what we all see in the world of legal world, in the legal system, when we say property rights, it finally comes down to the proprietary rights in immovables and movables, and not beyond that. It doesn't cover the intellectual property rights. It doesn't cover the personal rights. They are separate. They are to be dealt separately. It also doesn't cover, most important thing, the proprietary rights in personam. Proprietary rights in personam, like debt. If you lend a money to somebody, right, you have the right of recovery of that money, right? That's not a proprietary right, actually. It is a right in law of obligations. So that's how the difference between the law of property and the contract or the law of obligation exists. Now, what is the law of obligation is a separate matter. I'll come to that. So finally, what happens is, when we generally talk about property rights, it is basically the property rights in rem, that is with regard to the rights in the movable property and immovable property. The proprietary rights in personam, that is right of recovery of the debt, and these things are, they do fall under law of obligations as understood in the general conceptual analysis of common law. Now, what is this law of obligations? That's another tunnel within the tunnel in the common law. The law of obligation is that property rights in personam are part of the law of obligations. Fine. The obligations in common law may arise from four categories of breaches. One is the breach of contracts, right? If there is a contract of whatever nature for whatever thing, if you commit a breach, the obligation which is imposed by the contract, if a breach is committed, that breach is a right in personam to be enforced. So it is an obligation in personam arising from breach of contract. Then second is breach of duty, as we call it, tort. If there is a breach of duty, you all know it falls under the tort. Conceptually, it is a part of law of obligations that if there is a breach of duty, you are right to recover damages. You have right to sometime enforce the primary right of stopping a person from continuing with the defamatory publications. All that happens. This is how this law of obligation, the second aspect. The third aspect of the law of obligation is breach of quasi-contracts or implied contracts. This is a bit difficult branch of law, which usually the lawyers practicing in the commercial law, corporate sides come across. There are so many situations where there is no contract, but by way of a dealing which you are committed in the course of your commercial relationship, certain rights and obligations arise. They are treated like contract, though there is no express contract in that. The law infers a implied contract and addresses those situations based upon the principles of equity and good conscience. So this is a very interesting and important area which a lawyer will have to bear in mind, that you don't have to always look to the written contract in a situation. If some injustice is, if something has happened, you don't have to really see where the written contract is there or where the oral contract is there. There is something called by relationship, an implied contract arises that is called quasi contract. And if that relationship is established, if injustice is shown, the court will come to the rescue. And that is how the law of third part of the law of obligation is. Then the last part is innominate or residual obligations. There are certain things like you can't really put it strictly under any of this, but some injustice has happened. Then the court will come to the rescue in its own way, treating it as a violation of a right. Any right violated has to be redressed is the broad principle of law, that the principle of the rule of law, that no right which has been violated can go unredressed. It may be contractual right, it may be property, it may be contract. If else is there, the court is not bothered. Court will just try to accommodate it. If it thinks or if it appeals to the judge's conscience that there is injustice and the dispute which is raised by the individual is in the nature of a civil dispute, because if it is not a civil dispute, then the suit under section 9 of the CPC won't lie. As long as it is a civil dispute, there will be some remedy available, whether it is a right under property, whether it is a right in contract, or whether it arises from the implied contract of quasi contract, or whatever it is. Lastly, we call it the sort of residual classification. So this is how broadly the law of property and law of obligations are dealt in the common law. And based upon this, in India, we have statutes. We have Transfer of Property Act, we have Sales of Wood Act, we have also Intellectual Property Acts, various laws are there. Then Contract Act is there. So all these laws broadly deal with these concepts, or these concepts are inherent in these acts. So when you sit to interpret these acts, when you have an occasion to interpret these acts or to understand the transactions which you have come across as a lawyer, then you'll have to try to place yourself conceptually in these categories and try to interpret and analyze them. It's not necessary that every time a lawyer must consider himself as a person to sit and analyze in a theoretical manner. Much 80% of the law or 90% of the practice depends upon as we go by common sense, which is the correct way of doing things. But common sense also has a limitation. And when the limitation arises in common sense, we do have to look to the certain theoretical analysis to come to the conclusions or to seek guidance for better development of the common sense to do justice between the parties, or at least to do justice to the client for whom you're holding a brief. Then next I go to is the titles. So having dealt with the broadly the civil law as one falling either under the property law or law of the obligations, that is contracts, quasi-contracts, torts, or residual, then comes the titles. What is this title is? Well, it is a part of the law of property or the law of obligations. Every right has a source. There cannot be a right without a source in law. So the source of law is called title. When somebody says in common parlance, hey, what is the title for your property? Then you get flummoxed. What the hell it is? What is the title? Then you say, sir, I have got a sale deed. Okay, sale deed is a title. What do you mean by title? Well, this is a title that is the source of right in a strict theoretical sense. If you say it's the source of right, what's your right is this sale deed. Then you ask the question, what is the source of the right of the purchaser, the seller who sold the property to you? Then you further go, how did he get it? Then it further goes, how did he get it? Like that, you always trace the title of the property until you reach a stage where it is not possible. That is, if you go beyond 1850 in India, it's not possible to trace a title, because when the legal system was implanted on India, it proceeded with certain things that whoever is in possession of the property is considered to be the owner unless somebody comes and questions it. That's called lost grant in law. This subject you must have come across recently in Babri Masjid case, because the question arose, who has given this land to the Hindus or the Muslims who claim? Then finally the court, based upon the possession and the long practice of worship, came to the conclusion that presumed to have been granted to the Hindus. That is how the title was traced. But strictly speaking, in the legal parlance, there are four sources for the title. The first is a possession. If you have been in long possession of the property, it's called a presumed grant. Then it is presumed that you are a owner, unless somebody comes and establishes a superior title to that, right? The second is the prescription, which is akin to the possession, but it has certain special elements that you need not be in long possession for decades and decades or century. All that you have to show is a certain period, like adverse possession, 11 years or something. Then if it is shown that the other side, the true owner knew it, and he kept quiet, he acquiesced in your ownership, then you acquire a title. This is a second class. The third is by agreement. Well, the 90% of the transactions in the world, as you know, the entire growth of the trade and commerce in the world is by agreement. And so as with regard to the real estate development also, property, lands, everything. So agreement is a good title for the property. If you can show that you had purchased it from X, it's a good title, provided the seller had a title to sell the land. Then we'll have to search whether he had, and he had, so it goes on. Okay, the process. The last is inheritance. Inheritance means there's one of the great incident of law property in a broad sense, that is right of ownership of a property means it has no meaning unless I have a right to pass it on to my descendants or my children. That is an important part of law, right to property, right of inheritance. So inheritance is one branch of title where a person acquires a title to the property without doing anything, just because he was born as a son to X, whose property on his death will come to this person. So it's inheritance. It sometimes can come in the very lifetime of the father, no difficulty. Like in Hindu law, the father can partition and give the property to son. But it's inheritance. So you acquire it, your status. You don't acquire it by any other means. You acquire it by a status that you have been a son of a father who is the owner of the property, and on whose death or on whose instrument of will or whatever it is, he passes on the property to you and you become a owner of the property. So the title to the property in civil law are four. If I repeat them, first is possession, second is prescription, third is agreement, and the fourth is inheritance. So whenever you come across any problems with regard to the title to the property, please ask four questions. That is it by possession? Is it by prescription? Is it by an agreement like a sale deed? Or is it by a simple inheritance that he happened to be a son or a daughter, or she happened to be a daughter of a person who is holding the property? So that's how the titles are dealt with. Now the next question we'll go into, that is, what are the remedies in civil law? Classified. Every right, if violated, has to be addressed to. There has to be redressal to the rights. This is the fundamental concept of civil law. Further, it is a part of the rule of law. There cannot be any right which the law would say it cannot be redressed. Except a small branch of law, the rights or wrongs which cannot be redressed on the ground that they are not justiciable in law, like issues relating to the defense matters, issues relating to international relationship. You cannot try to enforce a right if it is founded in an international treaty, unless the international treaty is made a law in India. Under the constitution, there is a provision for the parliament to implement treaties. So you cannot claim a right like that. So you'll have to go through the proper process. Now, the remedies in law, in civil law, let us not talk about the public law. Public law remedies are different. That is writ remedies and all. In civil law strictly, conceptually again, there are two remedies. One, to enforce your primary right. Second, to enforce the sanctioning right. What in the hell it is primary right and the sanctioning right? You know, when somebody trespasses into your land or somebody threatens to trespass into the land, you feel that your right to ownership of the property, a right to enjoy the property exclusively is threatened, right? Now, you don't want a compensation for the trespass he has committed. You may like to have it, but more than that, what you like is an injunction against a person to stop from interfering, to stop from trespassing into the land. That's called enforcement of a primary right. That your primary right to enjoy the land, primary right to possess the land exclusively, to the exclusion of the whole world. That is what you are trying to or seeking to enforce. So it is a enforcement of the primary right, which is permitted in the law by issuance of injunctions or order of restitutions or several remedies available under the Specific Relief Act. If you see the Specific Relief Act, you will find the various remedies where your primary right is enforced. Now, what is this primary right is a little problematic, but best thing is to understand is that what is secondary right? Okay, what is sanctioning right? I would call it. Actually, jurisprudentially, it's called sanctioning right. The sanctioning right is payment of a compensation for the right violated. Whenever a right is violated, you are entitled to compensation provided you have suffered a damage if there is a loss. So if you have suffered a damage and if there is a loss, you are entitled to a compensation that is called sanctioning right, that a sanction is imposed upon the violator of a right or a wrongdoer. So these are the two remedies. That is, one is enforcement of a primary right by way of an injunction, restitution, or whatever. Secondly, enforcement of the sanctioning right, that is payment of the compensation. The first right, that is enforcement of the primary right, is a discretion of the court in common law. The court will not usually grant you the enforcement of a primary right unless it is satisfied in equity that such a right, such a remedy is just and equitable. The sanctioning right is, of course, a right. Nobody can say no. No court can refuse to grant compensation, provided it is proved that you have suffered a damage and there is a violation of right and you have suffered the damage. So this is how the primary right and the sanctioning rights are the two types of rights envisaged in the civil law, and these two rights are well engrafted in the Civil Procedure Code and Specific Relief Act of 1963 in India. Then you proceed to the next, the transfer of property. The transfer of property is an important branch of civil law. Most of the litigation that we come across in India relate to the transfer of property. The other branch of law is the injury law. If there is an injury to your property rights, then you sue a person in tort. You also sue a person in tort for injury to your rights in other personal rights also, but you also do it for the injury to your property rights. This right of ownership of a property, what we broadly understand, is a bundle of rights which includes right to enjoy the property exclusively and pass it on to the descendants. So when you constitutionally consider right to property or right to ownership of property, that means right to enjoy it to the exclusion of others. If others have a right of interference, then that's not your ownership. Then you are sharing in ownership. So right of ownership means right to exclusively enjoy the property and pass it on to the descendants, that is your children, on your death or before death, whatever you like. So that is the important aspect of right of ownership of the property. The ownership of property can be sold or co-ownership. A property can be owned by a single person or two persons, right? When it is common ownership, co-ownership, there are again two forms: ownership in common and joint ownership. Ownership in common means you together own whole property. Joint ownership means you own the property together with a definite share. Then we have can be further fragmented on time basis. Nowadays, you have come across a lot of the time sharing resorts where you have right to go and stay in the resort for a week or 15 days, whatever. So time sharing of the ownership of the property is also permissible. Then there is trust ownership between the beneficial ownership and can be also classified as a legal and equitable ownership. There can be a classification as vested and contingent ownership. These concepts are done based upon the convenience of trade and commerce, convenience of the general welfare of the society. The concepts of possession, again, are in three different classes. One is possession in law and possession in fact. So this is most important. You are possessing a property, you are possessing in law, possessing in fact also. Then immediate and mediate possession and concurrent possession. I did not really take time to delve into all these things in detail because that by itself a lecture for more than an hour. Just to point out that these are the different concepts in possession, that is possession in law, possession in fact, then possession, immediate, mediate, and concurrent possession. So whenever you have a possession dispute with regard to the possession of a property, don't get worried. These are the concepts which are all defined. You will get a definite answer for that if you check into the legal literature. Then law property, I need not much explain to you what is the Transfer of Property Act of 1982 regulates. It is basically extension of the law of contract with regard to the immovable property. The immovable property, the primary legislation which regulates in India is Transfer of Property Act. There could be some more laws to regulate, which you come across in the state laws relating to the land, like Town and Country Planning Act. It's a further regulation of your right to property, right to transfer land. We have under the Developmental Act, Town Development and Special Development in Bangalore also, the BDA. All these things are the further regulation of your right to transfer the land. But basically, the transfer of land takes place as a matter of contract, subject to the laws which are made by the state to further regulate the contract. And if the contract is in violation of those laws, then certainly it is an illegal transfer and cannot be enforced in the court. Then you see the law of property, that is the primary legislation of 1882. It includes both transfer of property in rem and in personam, since it deals with not only sale but also leases, securities, and mortgages. Right. The Sale of Goods Act of 1930 regulates transfer of movables, which it calls deliverables in law, as defined in the Sale of Goods Act. The Law of Torts regulates the injury caused to the rights, which may be proprietary rights or personal rights. Right. Broadly, when you see the litigation, there are two kinds of litigations we come across. That is the dispute arising from the transfer of property, or dispute arising from injury caused to the your property rights or your rights in person. Right. So these are basically either it falls, you sue it under the contract, you sue it under the agreement, or you sue it under the injury, that is in tort. Right. Now, the Transfer of Property Act codifies the law of regulating the transfer of interest in the property. The concepts are who can transfer. Next is what interest can be transferred. Third is are conditional and restricted transfers permissible, and who can be transferring. So the Transfer of Act deals with four concepts. One is who can transfer. Second, what interest can be transferred. Third, are conditional and restricted transfers permissible. Then fourth, who can be the transferring. Now, what interest is transferable? Let us deal with that. The transferable interest in the movable and immovable property can be both vested interest and contingent interest. The vested interest is dealt by section 19 and 20, and contingent interest is dealt by 21 and 22. I need not explain to you what is this vested and contingent. It has its own dimensions in depth. But broadly, this is how the law of the Transfer of Property Act is conceptually classified. Then the transfer ought to be absolute, except in case of lease, that is section 10, 11, 12. One of the fundamental concepts of transfer of property is the property transfer has to be absolute. It cannot be conditional, right? You cannot transfer a property to a person and say that he will not transfer it to anyone for 10 years. It can't be said. The law can say, there can be a law. For instance, in Karnataka, SC/ST Act is there. The grant made to a scheduled caste, a Dalit, has certain restriction that he cannot transfer it for some number of years. That's okay. That is the restriction imposed by the law. But between the two persons, inter vivos, when property is transferred, it ought to be absolute. It cannot be conditional. You cannot tell a person who buys your property that when he is going to sell or what he is going to do with the property. So one of the fundamental concept of transfer of property is that it has to be absolute. Then transfer operates forthwith. That's the most important in section 8 of the TP Act. Unless an intention is expressed or necessarily implied, you must take it that any transfer of property means it is forthwith, it operates. Then conditional transfer is permitted in certain circumstances. That condition precedent in section 26, conditional transfer to X and on failure to Y under section 27, or on happening and not happening in section 28 and 30, and conditions subsequent in section 29. These are all the details. I need not really get into that, but broadly, I'm trying to point out how the TP Act, that is Transfer of Property Act of 1882, has regulated the transfer of property, or how it has codified the law of transfer of property in India. Then we come to the topic called persons. In civil law, or generally for any law in the legal system, the rights are vested only in the individuals, that is, human beings, or in the artificial persons created by law. You cannot have a rights in the dead person. You cannot have rights in the animals. You cannot have rights in the unborn child. Although that certain interests are created in these people, which a living person has to enforce. So any law which regulates rights and duties, the subject of right has to be a living person, human being, or an artificial person. It cannot be in respect of a dead person. It cannot be in respect of an animal. It cannot be in respect of a unborn child. Although, as we all see, there has been a lot of movement going on in the world that unborn child is a person, has its own right to live, but is still considered to be a right of a mother who decides with regard to the child. But when she decides, and other things are different matters, but still it is considered to be part of the mother's right as long as the child is in the womb. With regard to the dead persons, there's nothing as such, right? With regard to animals also, there is a lot of movement in these days that animals do have rights, that Animal Act is there. But all these rights which are created in respect of animals are created through the human beings. The agency has to be a human being. The duties are imposed upon the human being to look after the pets, to look after the animals, not to kill animals, not to shoot at them. But all these duties which you hear under the various laws, the Animal Protection Act or Wildlife Protection Act, ultimately it has to be imposed upon a human being or a group of human beings who discharge those duties by protecting the animals. The animal by itself cannot be a subject matter of a right by itself. It has to be through a living human being or group of human beings or a artificial person created. Now, what is this artificial person created? It's a second class of person. One is a human being who is the subject of right. Second is an artificial person created. Artificial person created is a person created by law. When trade and commerce started picking up in the world, it was very difficult for a proprietary trader to trade around. And they thought that we need money, investment, others association. So the concept of artificial person was floated in the England, and East India Company was one such. In 1600, the British Crown issued a charter granting a status of artificial person to the East India Company to go and trade in India. So the artificial person can be created by a law, and it was earlier created by the Crown grant. It was a privilege, but thereafter laws have been made where you can easily create an artificial person by following the procedure laid down. For instance, the Company Act provides for creation of an artificial person, that is a company, and all that you have to do is to go and register by following the procedure laid down in the Company Act. The artificial person is created. An artificial person is created under the Society Act, that is for the non-trading purpose. It can be a cooperative society under the Cooperative Society Act. It can be a trust, or it can be any other as permitted by law. All that is required for an artificial person is he will be an independent person, that is artificial person, who will have right to sue and be sued. But finally, even in the artificial person, the liabilities get linked to the individuals. But there is a law that the liabilities of individuals are limited by what is assumed in law, not beyond that. That's a separate subject which company law deals with in detail, why such a liability limited and other things. I need not go into that. But broadly speaking, the subject of right could be a human being, group of human beings, or an artificial person. But a dead person, unborn, or a non-human being cannot be a subject of right at all in law. This is the fundamental concept which all have to remember when they come across any subject to interpret the law. Then comes inheritance. Inheritance appears very simple, that father dies and son gets the property, but it's not that simple. It's the most complex law, because the law is not only just common law. It is regulated by a personal law based upon the customs and practices. And what are these customs and practices differ from religion to religion. And therefore, the entire body of law is so complex that most of the litigations in the mofussil areas, that is in the towns and the villages, is with regard to the inheritance law. In fact, it was so much before 1950 that most of the lawyers who had a roaring practice had cases dealing with inheritance law. For instance, I remember, I not remember in a sense, I know it. That's what I have read and heard. For instance, a family in Dharwad had 3 rounds of litigation in with regard to the inheritance of the property. And in all the 3 rounds, the family appealed up to the pre-council in England. So that is, in fact, famous Bhima Bai case, it is called. You'll get all these references in the pre-council reports, AR pre-council, or you'll get all those things. In fact, the Supreme Court in 1963 had an occasion to comment upon this case also, that this is a classic case of a family dispute on inheritance, which had visited the pre-council in England thrice, not once, twice, but thrice. This is how the inheritance disputes have been dealt with, because inheritance law is a complex law depending upon the practices and the customs as interpreted by the court based upon the evidence which they collected at some time. And there have been a lot of variations in the precedents. There's an interpretation of the precedent, all that is gone on. And another problem in inheritance law is when you apply personal law, you do not apply the principle of justice and good conscience, because that's not permissible. The court has to strictly interpret what is the custom and the practice and apply. So the scope for the judges to do justice in interpreting or in declaring what the law is also very limited. As a result, there has been a lot of complexity in the inheritance law. Of course, the legislature has intervened, like 1956 Hindu Succession Act, various laws to correct the injustices as they think and deem fit, and done it. But even then, there has been a lot of litigation in this area of disputes. This is one thing. Then lastly, we come to public law. This is not a civil law in a sense, but I just thought I must deal with that to give a broader picture. The public law is, that is the constitutional law and the law made by the legislatures, that is the state legislature in India and the central legislature, that is the parliament. The public law is that they can certainly interfere into the contractual rights. They can modify the contract. They can terminate the contract. They can regulate your property rights, how you transfer the properties, why you should not transfer the property, why certain things are not permissible. All kind of restrictions can be laid down by the legislature. If that is the case, then what is the guarantee of an individual against the legislative interference? As such, today, after the 1978 amendment, there is no guarantee, because it is no more a fundamental right to property. It is a constitutional right, of course, under Article 300A of the Constitution. That is a separate matter. But as a fundamental right, it doesn't exist. Then questions are asked. What happens if a state decides to acquire your property? Can it acquire without payment of compensation? One of the fundamental attributes of a sovereignty is power of eminent domain. That is, right of the state to acquire the property, which is very essential for the welfare of the people. If state doesn't have this power, perhaps the administration cannot be carried out. All these developmental activities, what you have seen around, we see around, could not have been done if the state didn't have the power to acquire the land or a property of the individual. So this power of eminent domain is very important. But the common law had an unwritten principle which was very strictly honored in England, that no property should be acquired without payment of a compensation to the owner. Then question came, what is the compensation? And it was fairly said, the market value of the property. The questions started arising in India in a more serious manner after independence, when there was abolition of the Jamindari system and other things. And the Jamindars who had owned hundreds and thousands of acres of land, they said, well, you can acquire our land, you can abolish the Jamindari and take away our land, but then we are entitled to compensation under Article 31 of the Constitution and under Article 19, etc. Then they found the Parliament found it impossible to pay the compensation. The Constitution was amended in 1956, and then broadly the Constitution, as today envisages, is they have exempted certain laws which are intended for acquisition of the property from being challenged on any of the grounds of fundamental rights. The principle is that finally, as the Constitution stands today, the state can acquire the land, can acquire any property. But if the property, that is the land, which is in cultivation, is acquired, then the state is constitutionally obliged to pay the market value compensation as determined by the law. But if the state acquires a property which is not in personal cultivation, or which is an urban property, or any other property, then there is no strict obligation to pay a market value compensation. All that is obliged to be paid is the some compensation as decided by the law, which the Supreme Court has subsequently said that the compensation as decided by law does not mean some kind of a token compensation. It cannot be illusory. It has to be reasonable. But still, it's not a market value compensation. Therefore, you be ready, if your urban property is acquired, there could be a law that which may not give you the market value compensation. It's a different matter that so far the state in India, that is the center or the state governments, have been kind enough to apply the Land Acquisition Act, earlier 1892 and now 2013. And they propose to give a market value compensation as defined in the law to all those whose lands have been or properties have been acquired. But speaking constitutionally, the right inheres only in respect of those properties which are lands and which are under personal cultivation. Beyond that, it is the mercy of the legislature. It grants, it doesn't grant, doesn't grant. The Maharaja of Mysore, if his palace is acquired, he may not be entitled to the compensation at market value. The law which acquires his property, I'm just referring to Maharaja of Mysore, it could be any Maharaja. The law which acquires the palace or law which acquires the property itself fixes the compensation, creates a machinery by a commissioner or whatever, and whatever is fixed in the law is the compensation he is entitled to. Only thing or only obligation on the state is it should not be illusory, it should not be unreasonable, it should be reasonable compensation. So this is broadly the civil law in a nutshell. I'm not sure whether I should call it a nutshell, or I'm not sure whether I have completely dealt with it, but it's an attempt which I have tried to make in a short period of 45 to 50 minutes available at my end. And I thank you all, and I thank Mr. Vikas again for persuading me to speak. And I'm sure you all enjoyed, and I'm sure the youngsters and the practicing advocates will benefit by my talk. Thank you very much.
Indeed, quite enriching. And just what we say, it was also meaning, like they say, Mohan, which could be cherished to the mind and heart. That was the way. One question has come forward: distinction between tenants in common and joint tenancy.
Yeah, this is a legal distinction. I think we'll have to refer to the legal literature. You will get it. I can't really explain it in a short. Tenants in common and joint possession. Okay. I don't think I should spend time on this. You can certainly refer to the legal literature. You can just type on the Google. You'll get it. Okay. Any question which relates to the fundamental aspect which I have spoken, I would like to see questions.
Probably Mr. Guthi wants to speak.
Yeah. Good evening, Mohan, and thank you, Vikas, for the wonderful opportunity you have given us. And I have seen Mohan from very close quarters, and brevity has been his forte. And I enjoyed both his written words and also now the spoken word. One small point I would like to make here is when he talked about quasi contracts, there's a principle of quantum merit. You see that I just wanted to butt in and see as much as one earns. See, there are certain cases where you don't have any written instructions or agreement. So in that case, this principle of quantum merit comes into play. So that one point. The other point is that now there's a clamor for the uniform civil code. So with so much of complexity in the laws of inheritance and other things, I just want to dig into the brains of our illustrious classmate Mohan.
Yeah, Mr. Guthi, you will have to unmute yourself. आप hello लिख दो. Somehow he has also closed his video. Yeah, unmute, Mr. Guthi, you will have to unmute yourself. No.
Yeah, sorry.
Yeah.
Yeah, we can hear you now. Hello,
Yeah.
Guthi, you'll have to complete your. We didn't hear you the end part of your question.
No, I just wanted to have your opinion on the uniform civil code with so much of complexity.
Yeah.
Johnny?
From civil code is civil law, right? Relating to the personal relations, right? Right to marry, right to pass on the property, inheritance, and other things. And as I said, this aspect of the law is governed by the personal laws, and these personal laws, as Supreme Court, as Bombay High Court said, and which is being the law considered, is that they are not the laws as understood under Article 13 of the Constitution, and therefore they cannot be tested on the ground of Part 3 of the Constitution for violating any fundamental right, for discrimination, whatever it is. As a result, we have got a body of civil law today, that is the personal law, dealing with inheritance and marriage, which are on the face of it appear to be discriminatory and against the dignity of human beings. This is the problem. Now, to overcome this, the Constitution envisaged that as a directive principle, that state will make an effort to bring a common civil code. When they said common civil code, they didn't mean that Hindu law should be imposed on Muslims or Muslims to be imposed on Hindus. What they meant is really a civil law to replace the personal law based upon the practices and the religion. If that is the concept, what is it about then? The ultimate civil law, which common civil law, if it comes into picture, common UCC, is that it will have to liberalize the procedure for divorces. At present, the divorce is a very rigid thing. The procedure is very rigid. Of course, in the last 10 years, the law amended to provide for a mutual consensual divorce. But if the mutual consent doesn't come, then one has to sue, and that means that is a litigation of 20 years. So all these things will have to change. Secondly, the common civil code will have to make the rules of inheritance completely and non-discriminatory. In a sense, both sons and daughters will have to have an equal share, both in the ancestral property and in the self-acquired property. So if these things are addressed, a more liberal regime is envisaged, then certainly it will benefit the people. But it is a political decision to be taken by the government, because these are not that simple. It's not that only one community gets affected by the common civil code. All communities will have to shed their rights. Hindus will have to give up this joint family property concepts and all these things. Once the common civil code comes, then it all becomes the property of the father, who decides what to do in a manner which is equal to both daughters and sons. And that is the case with Muslims, that is the case with Hindus, Christians, or whatever it is. So are we prepared for a liberal regime in the marriages? Are we prepared for a liberal regime in the inheritance, giving up the religious practices and the customs, which we'll have to all decide? Usually, the people get excited to listen about common civil code, because it gives an impression to them that once that is imposed, the Muslims cannot have 3 wives. Okay, our vision is just limited to stop Muslims from having more than 1 wife. Or the real question is why a Hindu is stopped from having a 2nd wife. This kind of things come into picture. But the real problem in this common civil code is not this. The real problem is you should be prepared for a liberal regime of marriage, almost like a registration marriage, where 2 persons consent, then they decide to marry, they will marry. And if they decide to get out, they get out, as you see in the Western world. There is no need to one go through the elaborate procedure of suing for the impotency or suing on the ground of cruelty, all these things. So that kind of a simple procedure is to be provided for dissolution of the marriage, and a non-discriminatory procedure for passing on the properties to the descendants. So if all are prepared, well, it should be enforced. But that is the political questions which the parliament will have to take. If you ask my personal opinion, I feel UCC should be implemented, but I'm not sure it can be implemented even in the near future.
Sir, it was a pleasure hearing you. And
Thank you, Jambu.
Thank you.
Jambu has been my classmate. Jambu has been my classmate and one of the bright student in the college. He was much brighter than all of us in the college. Okay. Only that he joined the administration and rose to important positions in the government also. He was the officer on special duty to the chief minister, right? So he has seen the government at the very highest level, both at the state as well as at the center. Right. Okay. Anyone? Any questions?
Thanks for
Any questions on the
way you were
conceptual
putting
matter?
things, it would be gathered from that.
Yeah.
Yeah. So thank you, friends, for connecting with us. It is always pleasure hearing Mr. Mohan Katarki. It's a pleasure. Thank you, everyone. Stay safe, stay blessed. And those who have missed our sessions, they can always look forward on our YouTube channel, and previous sessions can also be watched. Thank you. Namaskar. Jai Hind.